I think we've divided this case into two separate arguments.
That's correct, Your Honor.
And you're going to start on the first issue. You represent the school district?
Yes, and this is the intervention case, the motion to intervene, Your Honor. Is that the one that you wanted to hear?
No, all right. We'll start that. You represent Arizona, then?
Correct.
All right.
Right, we have to
And I'll clarify that.
turn pages.
And not Nevada.
Good morning, and may it please the Court. Robert Elman for the State of Arizona. Your Honors, the linchpin in any Rule 24 analysis is, of course, the interest asserted by the intervener. And if a district court misapprehends the nature of that interest, it is bound to inject error into the proceedings. And that's what happened here. The trial court incorrectly perceived that Arizona was attempting to assert an interest that conflicted with the 14th Amendment remedy. But that was not so. In fact, Arizona was objecting only to a part of the unitary status plan that did not remedy a 14th Amendment violation. And that becomes significant, and it injects error into the process, because if any aspect of the unitary status plan to which the state objects exceeds the scope of the court's remedial authority, then it necessarily impairs Arizona's interest in setting its own education policy. And I think that the state's interest and the court's error both become clear when you consider two well-established precepts that the Supreme Court applies in school desegregation cases. The first is that the extent of a federal court's authority to act is strictly remedial. And under the language in the Milliken 2 case, anything the court orders has to directly address and relate to an established constitutional violation. To the contrary, the state's interest in education is plenary, so it extends to every facet of education except those to which a remedy is necessary in order to correct a 14th Amendment violation. Now, in this case, Arizona was not simply objecting that a culturally relevant course might conflict with Arizona law, but that a culturally relevant course is not a remedy for any finding below. And that's clearly the case here, Your Honor, because in the course of 40 years, there have only been two constitutional violations noticed by the court. The first is from 1978, and that is, of course, the desegregation aspect of the case, because the district court had found that there was intentional segregation, both in terms of student populations and hiring practices. The case went dormant, as you well know, for 25 years, and after the district court had concluded in 2008 that the Tucson Unified School District had actually achieved unitary status, that was appealed and this court reversed. But it reversed solely upon holding that the Tucson Unified School District had failed to live up to the terms of the 1978 agreement. And that specifically was its failure to monitor, evaluate, and report on the desegregation efforts by the district and the status of those efforts. So what one would expect in a remand of that nature is a court order that requires the school district to report regularly to the court and that specifies what information it must supply in those reports. And that's not what you have here. You have a unitary status plan that requires the school district to develop specific curricula. Now, the reason that exceeds the court's remedial authority in this case is because there is no nexus between development of culturally relevant curricula and any constitutional violation. It doesn't have anything to do with the original green factor violation, which is the student assignment problem, and it has nothing to do with the failure of the district to monitor, evaluate, and report on the status of desegregation. If there's no nexus between the violation and the remedy, then it's not a remedy at all, because again, it has to directly address and relate to a constitutional violation. And as we stand here today, the Tucson Unified School District insists that there is no green factor violation in its district. And in fact, there has been no finding to that effect for 36 years. Now, this is not the first time that a district court has attempted to require a school district to develop specific curricula. Two of your sister circuits have faced this very problem before, the Second Circuit in the Yonkers case and the 10th Circuit in the Keyes case. In both of those instances, The district court had required the school district to develop curricula, and both of those courts vacated that aspect of the district's order. The Yonkers court concluded that requiring curricula is only appropriate upon extraordinary showings. And again, there's no finding here of even a green factor violation. And in Keyes, the court was careful to point out that nothing in the Constitution requires a school district to create courses tailored to ethnic groups. Now, in this instance, given the absence of any nexus, if you look to the Supreme Court authority, we're not suggesting that there could never be an instance where a district court could not properly order a district to create this curricula, but it only happens, and Milliken 2 serves as an example, if you have culturally isolated groups and you have, and I just want to make sure that I'm quoting this correctly, you have a segregated school system that is so pervasively and persistently segregated that the district court finds a need for educational components that flows directly from constitutional violations by state and local officials. And you have nothing resembling that in this case, Your Honor. And of course, part of the collateral damage of misperceiving what the state was trying to assert as its interest is the equally erroneous conclusion that the Tucson Unified School District could somehow adequately represent the state's interest in protecting its education policy prerogative. Arizona opposed the culturally relevant curricula because it believed that it exceeded the scope of the federal court's authority. But the Tucson Unified School District changed its position and now embraces that culturally relevant curricular requirement. And the Tucson Unified School District respectfully has no stake in protecting the scope of the state's prerogative to set its own education policy.
If there were no lawsuit and the school district adopted the kind of curriculum program that it is considering here, would Arizona say that would be unconstitutional?
Yes, I believe you're referring to the Flores case, Your Honor, which is actually set for argument in this court in January. And of all the requirements in the Arizona statute that was implicated by the proceedings, there was only one aspect that the district court found was unconstitutional, but the other aspects of it, which prevent a school district to teach anything that promotes resentment toward a race or class of people, was upheld as constitutional. And also the prohibition against advocating ethnic solidarity instead of the treatment of pupils.
That's the question of whether the plan would violate Arizona law if the school district adopted it. But I was asking whether it would be unconstitutional for the school district to adopt voluntarily the type of plan that we're considering here.
Well, it would if the plan is adopted by federal compulsion of the district court, Your Honor, regardless whether the Tucson School District agrees with it, because the Tucson School District can't waive the state's ability to protect its interests in that prerogative. Now, the current Tucson Unified School District Governing Board may agree with the policy preference of the plaintiffs and of the Department of Justice, but the state of Arizona does not. And as long as that's the case, their interests diverge, and any order that compels Tucson to develop these curricula, whether Tucson agrees with it or not, still exceeds the scope of the court's remedial authority. So it would still be unconstitutional unless the state of Arizona were to waive it. And of course, it hasn't delegated that prerogative to the federal government in this case, or to the Tucson Unified School District. And then finally, the idea that requiring the development of culturally relevant curricula doesn't actually impair any Arizona interest is palpably wrong, because now that you have an order from the district court that actually requires the school district to adopt it, there has already been an encroachment on the state's education policy prerogative. So the damage is already done. And of course, it invites repetitive litigation. To sum up in the remainder of my time, Your Honor, if the court agrees with the state of Arizona's position that requiring development of culturally relevant courses exceeds the scope of the district court's authority under these circumstances, then the appropriate remedy is to vacate the portion of the order that requires the development of that course. And there wouldn't be a need for any further remand. Now, if for whatever reason the court were to conclude that culturally relevant courses are within the legitimate scope of authority for the district court, a remand would nevertheless be necessary, because what you would then have is an authorized usurpation of what would otherwise be Arizona's exclusive prerogative. So surely Arizona would have to have a place in the proceedings to participate so that it could challenge many of the hotly disputed factual issues in this case that end up in that order, so that we know that if there's an imperative to correct a vestige of discrimination that, again, hasn't been shown here, but if the court were to conclude that, then Arizona would surely have the right to contest portions of it that they felt would not eradicate the vestiges of prior segregation.
Well, you are litigating, as you mentioned, in this court, the issue of the validity of the Arizona statute.
Correct, Your Honor.
And so we can't assume that even though the district court said that only one provision of your statute was unconstitutional, the plaintiffs in that case are still contending that other sections, I assume, I haven't read the case, but isn't it appropriate to have the question of what the constitutionality of Arizona's interest in these types of curricula are? Isn't it appropriate to have that litigated in the other case?
Well, it's certainly appropriate to litigate it in the other case, Your Honor, because they're challenging the substance of the statute itself and whether it could apply to Tucson or any other school district and requiring a district to meet the state's criteria. But it wouldn't affect the court's disposition of this case, because the aspect of the plan that the state is objecting to doesn't have to do with the constitutionality of its statute. It's kind of a red herring in this case. The court treated Arizona's interest as simply making sure that anything in the unitary status plan didn't contravene an Arizona statute. And that would, of course, if that were correct, and it isn't, that would lead the court to think that it was simply a matter of whether Arizona's statute was constitutional and whether or not that could overcome the 14th Amendment imperative, which, of course, it can't. But that's not what Arizona's complaining about in this case.
Thank you.
Thank you, Your Honor. And I will be very brief, Your Honor. An Arizona administrative law judge obviously can't vacate part of the district court's order. Arizona's actions in this case cannot have been premature because the damage is already done if, in fact, the district court's unitary status plan exceeds its authority. And there was no mention of that in the argument you just heard. Curricula is ultimately the state's responsibility. Only the state of Arizona can command a school district to develop a particular type of curricula. Curricula is, there's some discretion about how you develop it, but it has to meet the state standards that are highly specific for each grade level. And in fact, if a district fails to do that, the state steps in, takes over the district, and does everything, including curricular development. Now, the nature of the motion below turns on the language of the court's order in disposing of it and the matters addressed there. And I just want to point out that when the district court issued its order denying what was captioned as the second motion for reconsideration, it said that it was timely in respect to the state's ability to affect the terms and provisions contained in the USP. Now, that's an analysis for a motion to intervene. It's not analysis under Local Rule 7.2 for whether there was good cause.